All right. Well, thanks for joining us here on our YouTube Live. I know a few of you were a little disappointed that you missed me last week. Unfortunately, I was in trial last week and couldn't make it. I was out of town in a jury trial. And actually, we settled the case. We didn't end up having to go to trial after all. But I was still out of town, and I was at an airport during the normal time. But I am happy to be here right now and excited about today's topic. My tenant requested repairs. So how do I know which ones I actually need to do? We're going to get started with this topic in just a second, but I want to introduce myself. I am Ernie Garcia, landlord attorney, and we want to get moving with our topic in just a second, which is all about repairs. But I do want to welcome all of you who are here and give a little time for anybody else who's going to join us. For those of you who have questions, I definitely want to get to those questions. We've got a number of you who've submitted questions that I want to get to, and we'll get to that in the second part of the program. But first, we're going to talk a little bit about a little bit about the repair issue and the questions that we have. But for those of you who want to submit questions, whether it's on the topic of repairs or any other topic having to do with landlording, if you are interested in doing that, we strongly encourage you to participate by adding those questions into the chat. As you see here, hello is always nice. Good to see you there. We welcome all of you to contribute to the chat. And one way you can do that is by saying hello, but you can also send in your questions. I want to answer your questions because I want to make sure that this is a helpful opportunity for you to get your landlord-tenant questions answered from me while you've got me here and we're locked and loaded on today's live. For those of you who don't know how to submit questions, you can submit questions ahead of time, like many people do, but you can also submit questions through the chat. So if you're here and you haven't submitted something ahead of time that I'll have a chance to take a look at, I strongly recommend that you add that into the chat. But for everybody else, you can either join our Facebook group, Texas Landlords, where we have almost 9,000 members statewide. People are contributing and joining in and adding their 2 cents, but also adding their questions for me to answer on this live. I've got those questions right here, and we'll get to those in just a second. But for everybody else who is interested in submitting something, feel free to go ahead and add that to the chat. If you're not in Facebook, and not everybody is, you are welcome to join us through our newsletter, and you can submit your questions. We have a weekly newsletter that you can join by either calling us or texting us. The number is there along the bottom of the screen, or you can shoot us an email at info@attorneyeg.com. Whatever way you choose to get a hold of us, we want to be right there with you and give you an opportunity to submit your questions, like the handful of questions that I've got today. But without further ado, let's go ahead and get started on today's topic of repairs. And so, repair issues tend to be the kind of stuff that create tension between landlords and tenants. And so we want to take some time and talk about the kinds of things that, landlords need to pay a whole lot of attention to, and the kinds of things that really, don't require as much attention, because that's really where landlords get tripped up, is what kind of things are absolutely essential and what kinds of things can I just let slide. And many of you are thinking already, I didn't know I could let anything slide. I thought I had to, address every single, repair request that came to me. But that's not necessarily the case. And so when we're talking about repairs, we want to make sure you know the difference between those things that are absolutely essential and those things which are, a bit more cosmetic in nature. And so if you don't know the difference, it's very easy to get tripped up by, common requests that are made. And, sometimes, landlords will have this tendency, well, as soon as a repair request is made, I absolutely have to do something about it. And there's no questioning. And so they're rushing to the house, and it turns out that the thing isn't that big of a deal. But to the landlord, if they're not addressing it, they feel like they are somehow in breach of their agreement. And that's just typically not the case. And so unless you know the kinds of things that are absolutely essential, the kinds of things that can otherwise, be, taken care of later, you're always going to get tripped up. So the question for everybody is, my tenant requested repairs, so how do I know which ones I actually need to do? And so the first thing that I want you to think about is, is this a matter of, absolute necessity? And the way that the Texas Property Code talks about this is really quite specifics. And the Texas Property Code specifically says that the repairs that a landlord is required to do are those defects on the premises that materially affect the health or safety of an ordinary tenant. So the first test to really consider is this something that affects the health or safety of an ordinary tenant? And there isn't a bright line test for all repairs that necessarily do that. But ask yourself this question. They've asked me to come in and fix this thing. Is it in any way going to affect anyone's health or anyone's safety? Let's give you an example. They say that the toilet won't stop running. The toilet won't stop running. Does that have a material effect on anyone's health or safety? Well, the answer to that one is probably not. That's not going to cause someone to be in physical danger, and it's probably not going to lead to any kind of illness. What we're talking about when the toilet keeps running is an economic question. So maybe you have something that fails the health or safety test, but it's going to cost you money, or potentially it's going to cost them money, and then they're going to come and get that money out of you. In that situation, yeah, it might behoove you to act with, speed and efficiency to make sure that running toilet isn't just sending dollar bills down the drain. So not everything just falls under to that. If you're using the Texas Realtors lease, that Section 18, well, it has nothing to do with health. It has nothing to do with safety. So I don't technically have to do it. A lot of times also landlords will hit me with this part. It says, well, that section of my lease says if they're not current on rent, I don't have to address it. Well, maybe not, but a leaky toilet is going to run up a bill. And if it's on you, because the utilities are in your name, you're not going to be real excited when you get that massive bill for a massive amount that you could have addressed early on in the process and affected in a way that resulted in no money against you. Now, you might be saying, Ernie, well, joke's on them. All the utilities are in their name, so that's technically their problem. Well, it's not if your lease says, tenant, you're not allowed to touch. You're not allowed to make any repairs on the property. In that case, once you are put on notice that money is literally going down the drain, you got to do something responsible about it. And so the real issue is, are you acting with diligence? And so the first bright line test, again, does it affect their health? Does it affect their safety, right? If a storm came and blew off the roof, yeah, that's going to affect both health and safety. You got to deal with that pretty quickly. Now, naturally, if the roof's gone, you're going to declare the whole house uninhabitable. And under 92.054 of the Texas Property Code, you can just call things quit right then and there. But let's say it's not the roof, and let's say instead it's the front door. And something happens where the thing just comes right off the hinges, and there's not a front door. It wasn't caused by a storm. I don't know what caused it, but it also wasn't caused by the tenant's negligence or the tenant's misuse. Maybe the wood is rotted on the frame and termites got it, again, through no fault of the tenants, and the door just ripped right off of the wood frame. And so, yeah, you got to do something about that quickly, because that does affect health and safety. And typically when we have a health or safety issue, those make the most sense. But you also have to consider, what about cost? Is it costing the tenant money because of some defect that I am responsible for? Or is it costing me money because, again, the utilities in my name and that water is going down the drain? You're going to want to act, quickly with regard to these claims, because ultimately you might be on the hook for these costs. So let's say it's not an issue that has to do with safety, or it's not an issue that has to do with health, and it's not an issue that's costing anybody money. The rest of these kind of fall into issues of convenience or cosmetics. And so the question really comes down, what did your tenant reasonably expect out of the use of the property when they signed the lease? And so if you said in your lease, I'm going to keep up this patio and you can use it for your gardening, let's say. And then a storm comes over and knocks down the patio. Of course, that's not a health or a safety issue. Of course, the fact that the patio is gone isn't costing anybody any money. But if part of your lease agreement was, hey, I got this patio here specifically for my gardening, which was somehow a part of your lease, now they're missing out on the benefit of that bargain, and it's diminished the value of the lease. And that's very different from this other scenario. The house doesn't have a patio, and they step out and think, it would really be nice if there were a patio out here so that I could enjoy my time on your property better. I demand that a patio, which is not there, has never been there, was not part of the lease, be installed, because too much sunlight is coming in and it is an inconvenience. Listen, in that situation, you have no responsibility to the tenant. You have no obligation to act. If they're wanting you to do something to alter their inconvenience, again, from something that was a condition that was present at the time of the original lease signing, you take the property as is. If all of a sudden some inconvenience pops up, that's not enough to force you to act, nor are cosmetic issues, right? And so if something is purely cosmetic, for example, the paint on the walls, the fact that they're tired of it, or they've been there for 3 years and they're still on the hook for a 4th year, doesn't mean that because after 3 years they've gotten tired of something and they would like a cosmetic change, that you are required to, cover those costs. Now, as a customer service thing, you might undertake to install a patio, or you might undertake to paint the walls. But just because something's been around for a long time and could use an upgrade, or something hasn't existed from the beginning but could use an upgrade, doesn't mean you are obligated to act. So understand the tests that are involved in most leases. The most basic, safety and health. Is this something that deals with safety or health? You're likely going to have to deal with it, and deal with it quickly. Is it something that involves cost? If it does involve costs either to you or to your tenant that was caused by, again, through no fault of the tenant, then you're probably going to want to act quickly, because you don't want some claim against you for something that went wrong that's costing them money. But if it's a matter of, convenience or cosmetics, you got to decide whether this customer service effort on your part makes sense for you and your tenant, or whether it's something that really is unnecessary that you're just not going to spend the time and dedicate the effort to. Now, there's a give and take, of course. There's a diminishing return if you keep doing things, but don't really get anything out of it from your tenant. But sometimes you might invest a little money, and that turns a tenant who was going to be gone after 4 years, who reconsiders and maybe stays another year or two. And that could mean a serious increase in your profitability as a landlord, especially if that rent can go up a little bit, justifiably so, because of the investment that you have just put into the home. And it doesn't have to be a dollar for dollar thing. You might find that keeping that tenant itself has great value to you. So make sure that when you get, requests for repairs from your tenants, that you're taking all of these factors into consideration. Not every repair request is created equally. If it's not health or safety, it's not costing anybody money, you really got to slow down on these requests. Now, if it does matter that, for example, the value of something, this is where we talk about economics and money. If something is broken and they're no longer getting value, I'm going to give you an easy one, the pool, right? If the pool, the pump for the pool just isn't working and now the pool isn't usable, well, if they rented your house and it had a pool and one of the selling points was, hey, we've got a working pool, and all of a sudden it's not usable anymore, again, it's not a health and safety thing. It's not costing them any money. But the fact that it's broken may end up diminishing the value of the property. And so you really have to think, do I want to wait for a lawsuit, a claim for diminished value, or do I just get on it because it keeps my client or my customer happy, my tenant happy? And it's part of the original bargain. When they signed the lease, it had a working pool. I'm going to maintain that working pool. Now, you may have something in your lease that says, look, this thing's on its last legs. You and I agree that once it goes out, it will not be repaired or replaced. And it's perfectly fine for you to mention that in your lease. And if, in fact, the pool pump goes out and you say, look, I'm not going to invest any more money in, and you agree that no more money will be invested in it, then yeah, at that point, you have bargained, and it was anticipated that at a certain point it would go out. Again, different story. But in order to maintain the original expectation of your lease, if something does go out, even if it doesn't affect health, safety, or money, you're probably going to have to repair it because it's probably going to affect the value of the overall lease. Landlords, I hope this was helpful to you when you are considering your leases in the future. Let's get to a few of these comments. Hey, good afternoon, Ernie. Thanks for taking questions. You are very welcome. I anticipate taking even more questions from you guys. Much appreciate the opportunity to learn and be informed. Well, I'm glad you're here, and I hope you do learn quite a bit. Ernie, so glad you're here. Well, I'm glad you're here, and I'm looking forward to getting started on these questions. So I'm about to get going. Again, I want to welcome those of you who are here. If you've got questions that you would like to add to the discussion, I welcome you to do that right now. We're going to get started in just a second with our first question. But for those of you who don't know, again, join us either through Facebook or through our newsletter, and you can always get your question added to the chat. And we're going to go ahead and get started with our first question right now. Give me just a second to pull this up. All right. All right, here we go with our first. Sorry about that. Technical issues popping up. There we go. All right, there we go, and let's add it. So Zoila D from our newsletter asks, my question is regarding breaking the lease agreement and how to handle it in Texas. My lease agreement does not include a clause stating a penalty for early termination of the lease. How much can you charge in case the tenant is leaving in good terms? Well, and this is something that we cover quite a bit, is this issue of early termination and what to charge and what is ultimately appropriate. And I'm glad you asked, because a lot of new landlords are just not real clear on this. Now, personally, Zoila, I don't include penalties, and don't look at it in terms of penalties. I don't include penalties or fees or charges for early termination in my own lease. That's actually not needed. What is important to recognize is that at all times, the entire balance of the lease is owed from the moment they sign that lease. And that's the most important thing to remember at all times, is that the full balance of the lease, so that if they leave at month 3 of a 12-month lease, guess what? They still owe all the way to month 12. Now, some of you really smart people are out there, and you're saying, well, Ernie, I don't think that's accurate. I don't think you're giving, proper information out there, because I know that the law requires that a landlord mitigate their damages. And to you, I'm going to say, good job. You are paying attention. It is true that landlords are required to mitigate their damages, but most landlords don't know what that means. So I'm gonna help you guys out. What does it mean for a landlord to mitigate their damages in the state of Texas, and really in most states in the U.S.? That means that whatever you can salvage from the lease to prevent any additional losses, you ought to do that. And so in order to accomplish this, you're going to have to make a good faith effort to find a new tenant. But it could take you 1 week. It could take you 10 weeks before you find that tenant. So how do you calculate what you charge your outgoing tenant, especially if you're on good terms with them? Well, essentially, let's not look at it in terms of, things worked out really well with them or things didn't work out. Instead, what I tell landlords to do is to consider the market, what time of year you're in, and just how hot is your rental market right now. If you don't know these things, you need to find them out, because these details are extremely important when you're determining whether or not it makes sense at all for you to bargain this way with your tenant. If it doesn't, it might be better for you just to say, I don't feel comfortable with this, because I just don't think I can get anything good at this time, especially if you're closer to the end of your lease. But let's presume, for argument's sake, that you're nearer to the beginning, and look, it's 9 months. It won't take me 9 months, but in my market, I've found that it's going to take at least, for this time of year, for this type of house, for this asking price, it's probably going to take me 45 days to find a new tenant. That means that even after my tenant leaves, I'm going to need some time to rehab the property, list it, and it's going to take me 45 days from that point, from the point of listing, to find somebody. So in effect, I'm going to lose 2 months of rent. And so now you start thinking in terms of, what are my likely damages? If you're thinking, well, I'm likely to lose, say nothing else, 2 months of rent in unpaid rent that I'm just not going to get from anybody until I get that new tenant in. And so by knowing that boundary for yourself, now at least one point to bargain with that outgoing tenant and say, look, in my estimation, I'm going to lose at least 2 months of rent. So that's the baseline. That's the minimum I would have to charge you if you plan to leave early. And your outgoing tenant may be perfectly fine with that. And typically, what I would argue in a situation like this, when you know it's going to be 2 months of rent, don't touch or apply the security deposit. That's just not a good idea. Keep the security deposit to cover damages and to cover additional costs over and above those 2 months of rent. Now, this presupposes that you don't pay anything to list your property. But guess what most landlords do? They pay somebody some fee to list their property for them. And if that's you, then it's not just costing you 2 months of lost rent. An additional part of your calculation is it's costing you a reletting fee. So add that to your total. Like, oops, I didn't think about a reletting fee. So it's 2 months of rent and then a third month of rent, because that's what my person charges me to list this property when I want to list it on the MLS or wherever you list it or wherever your person lists it. That's minimally what it's going to cost. So that may be less attractive to your outgoing tenant. They may say, well, after all, I don't think I'm that interested in moving out because that's expensive. You're going to hold my security deposit and charge me 3 months? Well, if that's the cost, that's the cost. And you have to be upfront with your outgoing tenant that this is what you're going to lose. And you're not losing it because you're doing anything wrong. You're losing it because they are leaving early. Otherwise, they're on the hook and they're welcome to stay all the way through the end. So these are tough questions you got to pose to yourself when you're determining the number. But there are also, tough facts that, your outgoing tenant is going to have to consider. And if they're unwilling to pay these amounts, I would be unwilling to let them out without letting them know, look, I'm otherwise going to have to come after you for the entire balance, because that's ultimately what's owed. To get ahead of this, I tend to, encourage landlords to be upfront with their, tenants from the beginning. There is no early out. There is no early termination. Whatever it turns out the actual cost is going to be, whether that's, 3 months or 4 months worth of rent, I don't otherwise allow tenants to leave early. You are on the hook to the very end. But if you want to discuss that, this is the way we calculate it. What am I likely to lose? And are you willing to pay that? If so, sure, we can talk about an early termination modification of our lease. But if that's not something you're comfortable with, then unfortunately, I have to seek the full slate of damages that I'm going to experience against you. And that's probably going to involve a lawsuit of some sort. So to avoid that, let's just stay to the end of the lease and not discuss early termination as an absolute. So I hope that helps. I know a lot of you are jumping in. Let's see what we got here. We'd love to see you do a video on squatters. I've done one before. Courts do not seem to know what to do when you file the affidavit. Let me tell you, I'm having the same sort of issue when it comes to these affidavits. I've had constables tell me, I have no idea what you're talking about in terms of, changes in the law. But the law has changed. And yeah, it's going to take a little while, unfortunately, for some of these constables to get up to speed on these things. In a lot of ways, they're going to have to seek out the assistance of the county attorney so that they know how to proceed. But yeah, this has been a thing. If a tenant requests maintenance, can a landlord counter with damage caused by tenant, like service animal destroying sod or interior? I don't know about counter, but so let's say there are two separate things going on. You've got an animal that is service animal or pet, doesn't really matter. If that animal is causing damage to the property, let's say, for example, they've ruined your award-winning, flower garden. Just totally went in and tore it up. And it's going to cost you X, let's say $400 to replace all of those flowers. Well, that's a conversation you're going to have with your tenant, independent of any requests for repairs that they make. I would definitely send them a notice of default and say, look, I've got an estimate for my yard guy. He said it's going to cost $400 to put all these. I'm going to pay for it. And then I'm going to send you a bill because your animal caused this damage. And if they're unwilling to pay, that's probably already grounds for you to start the exit process with this person. But that's the rule. They are on the hook for any damage that they cause to your property. And again, that's independent from a legitimate repair request they may have that's going on the inside. Let's say the AC has gone out. and it's July. Well, that's definitely going to have an effect on an ordinary person's health. When it's 105 outside and it's 92 inside the house, that could lead to health issues. And so, yes, it's imperative that you deal with that. Also, the place had a running AC when they came in. You're talking about a diminished value claim if all of a sudden the AC no longer work. So I strongly recommend you get in there and fix that, but don't hesitate fixing the other and then issuing a bill. You don't have to hold one repair hostage for the other. In fact, that would probably be improper. I would conduct both. You don't bill them for the AC work, especially if they had nothing to do with the AC going out, but definitely if they had everything to do with the flower bed being destroyed, issue them a bill for that repair. Let's see, you gave an example of asking 2 months rent. What happens if the 2 months go by and your property is still vacant? How do you recoup the additional damages? Well, that's why you hold on to the security deposit as well. So that's there. If you miscalculated, the truth is you probably still have a cause of action against that outgoing tenant, unless you resolve for a static number, right? And in most cases, that's probably what you're going to do. And again, if you miscalculated and it turns out to be 7 months, you really got to ask, are you doing everything in good faith to find a replacement tenant? Or did you just really, miss the mark in your evaluation of the rental market in your area? If that's the case, well, I mean, it's a little harder to be sympathetic. And it's going to depend on the way you framed your modification of your lease agreement. If it's you asked for one number and both of you gambled that number would be adequate, then you might have brought finality to it. You can word it in a way that says, look, if there's additional costs, you agree to pay because you are on the hook all the way to the end, but I would make sure that your agreement is open-ended. That might lead your tenant not to enter into that agreement because they may have this suspicion, well, what if you just sit on your hands and take all the time in the world? I don't want to be on the hook because you acted in bad faith. So that's also part of the bargaining procedure. To get better advice, I would ask somebody who knows your market very well. A local realtor might be able to do that and tell you, look, houses like yours, 3-bedroom, 2-bath, in this price range, they're going like hotcakes. Every 3 weeks we find a new one. Or I've seen too many houses like yours sit on the market 45, 75, 90 days. You need that live information from someone who knows the market well. You rock. Been following me from the beginning of your channel. Well, I'm glad. I know there's a lot of people who've been here from the beginning. We've been going for about 7 years, and I appreciate all of you who've been around for the long haul. Thank you so much. All right, I asked a question on Facebook about any obligation I have to the tenant for repairs that make it challenging to live there for a few days, such as foundation repairs. Take a couple of days. Let's see. Manchester 24. Yeah, if your question's in here, I'll definitely, here we go, Tom Manchester. Yeah, I've got your question, Tom. I will get to that in no time. And then you add interior piers, for example. Yeah, I will get to your question. It is coming down the way. So let's jump back into the prepared questions. Here is the next one. Karen Coulter from our newsletter asks, when a rental application is approved and the new tenant intends to move in at the end, I lost my spot. Intends to move in at the end of the following month, I typically request half the security deposit to take the property off the market. Okay. A rental application is approved. The new tenant intends to move. So you got a new tenant intends to move at the end of the following month. I typically request a security deposit, take the property off the market. Recently, I had instances where tenants decided to back out of the process after this step. Given that these renters are often highly budget conscious, do you have any recommendations for improving this process or handling these situations? Okay, well, let's talk about a couple of things. First, is this, and I want to make sure, it sounds like you're still in the application process that you haven't gotten a lease signed, I am not a fan of taking money outside of the signing of a lease, because then you've got this, and you don't have solidly agreed terms. Because if you're taking money as a placeholder, that's not a landlord-tenant matter. That's a breach of contract matter that goes under general contract principles. And that, again, I'm not a big fan of that. I would prefer that you get a signed lease, you get first month's rent, you get the security deposit, and you get ink on your paper, because then they're on the hook, as mentioned before, all the way to the end of the lease. And that's always you in the driver's seat. Once you shift, any authority to the other party, they're gonna pull garbage like this, and you've got less recourse. So if you're asking me what I recommend, get that lease signed, take the full first month and security deposit. If they can't pay it, they can't hold it. That's the only way you're going to pull something off the market, because otherwise you have to have a separate agreement that establishes good terms of what these rules are. And I don't recommend signing separate contracts for that interim. If you're going to take money, take all of it. If you're not going to take all of it, don't take any of it. That's typically my advice in this situation. Okay, so we'll go on and go to the next question. And there we go. Elaine, renter announced 3 months before contract completion that they bought a house and they're moving out. Congratulations. How nice. The lease was strict, 1-year contract. What do I do in a case like this? The house also needed upgrades and rent raised. So finding someone to rent for the remainder of the contract was very hard. Well, as mentioned before, this is where it's important to know, the outgoing tenant, how long is it going to take you to find somebody after you had to do upgrades and different things? How long was it going to take you to find a suitable replacement tenant? Remember, they're on the hook all the way till the end of that 1-year contract. All of that is 100% enforceable. Guess what they have now? They've got real estate. And while even if you sued them, and you couldn't foreclose any lien against that real estate, but you could create a judgment lien with an abstract of judgment and just park it there, because the moment they sell that property or they move from that property, it no longer has that same homestead protection. And guess what? You may lock something in 2026 that you're not going to collect from until 2031, but it'll be waiting there. Your judgment is good for at least 10 years after you abstract it. So, I would say that someone with a valuable asset is worth going after if you know that you've got a viable claim. So in terms of letting them out after just 3 months, great for them to have bought a house. But again, they owe you those additional 9 months in unpaid rent, and I wouldn't easily let them off the hook. So, whether or not they're going to agreeably pay any of those damages, may be a different story, but they certainly owe them. And so, don't be fooled by them and thinking that you have no recourse. You have the entire length of that contract, as long as you act in good faith, to force them to pay the remaining balance. You're entitled to it, and you should get it. And so, keep fighting for that. If you know where they live, and again, if they own real property, it's going to be easy to find them. You track them down through the property clerk of the county, especially if you know they bought it in the same county where the rental is located. Track them down, give them your demand for the amount that they owe. And, if they're not willing, you might want to talk to a real estate attorney about a potential lawsuit. Hopefully it doesn't get to that point, but it might. And considering what your damage calculation was, it is something that they lawfully owe. The fact that, The fact that, they don't want to pay is not the same. The fact that, they bought a house doesn't, void their contract with you to pay the full 12 months. Now, remember that the key is that you can demonstrate that you, in good faith, went out and mitigated your damages and found a replacement tenant. And as long as you did that, you're on the right side of the law. So I would encourage you to stay on them if they're still connected to you somehow, but make sure that you're doing whatever you can to collect those unpaid portions of rent that are in fact owed to you. So that's that. Question number 4. Jeanette Tyler writes, rental was leased to mom and adult son. Mom paid the deposit. Mom moved out after 3 months, and the deposit was transferred to son with a new lease reflecting only the son on the lease. 1 year later, son moves out, non-renewal. Who gets the deposit, son or mom? Well, that's going to depend on how things transferred. Did mom sign anything saying she waived her deposit? If she didn't, then the deposit belongs to both of them. It doesn't matter who pays. What matters is who was obligated to pay. That's ultimately what matters. And it doesn't matter that mom left and any damage caused on the premises was likely caused by the son. They're both on the hook. I would not have modified the lease without mom's signature and her waiving interest in the security deposit. I wouldn't have modified the lease to reflect only the son. I might have terminated the first lease, refunded the deposit to both, signed a new lease, took a new security deposit, and started from scratch. That's what I would have recommended. In this case, I would say that the lease, that the deposit probably still belongs half to mom and half to the son. They can sort that out themselves. But if you're holding a security deposit that stems from an original agreement with mom and son, unless mom signed anything disclaiming ownership of that lease, you probably owe her share back to her. And I don't really know how you're going to get around that. So, I think she's probably still got a pretty valid claim to that lease, unless you reach out to her and just ask her outright, is this still something you're interested in? Do you have any expectation here? Otherwise, she might be expecting some kind of refund. And I don't know if she's got that actual expectation on her mind or not. But if she does, it might be because she recognizes that, hey, she paid it. And at the very least, she's entitled to half of it. So, what is the function of that transfer? I don't know. Was the first lease properly terminated? From this fact pattern, I just don't know. But if it wasn't, chances are very high that you do owe mom at least half. Again, it doesn't really matter who wrote the check, who handed over the cash. What matters is who was on the hook for that deposit. They're also the ones who are entitled to a refund and to notice of any itemized deductions that were taken from that security deposit in the end. So that's for you to consider. Let's go ahead and move on. Next question. Besnick Nick Hacks. We did a background check on a prospect and came back showing no evictions. Excellent. Prospect did now give us any prior rental. I'm sure I meant not. Prospect did not give us any prior rental information and stated they did not have any evictions. Sounds great. We only found out when we did a rental verification from the background check. No eviction showed up on the background check. Legally, why wouldn't an eviction for over $3,000 from 9 months ago not show up on a credit check? Well, this is a complicated question because I don't know exactly what source you used. And the truth is, a different source is going to have, different, realistic expectations. And if you used a crappy service provider, you're going to get a crappy service. I don't know that that's the case. I also don't know whether or not, there was some fudging of the facts in terms of, names, dates of birth. It could be a similar name that you found. I don't know how these things were confirmed. But if the individual did just straight up misrepresent themselves, in their application, I mean, that in and of itself is for sure a violation of the lease and would be, suitable grounds for an eviction. But again, I don't really know how this was missed, except that maybe whoever did the search just didn't do a thorough enough job. Unfortunately, that does occur. And, the only solution to that is to fire those people. And, I don't know if that's going to bring you any solace. But yeah, that's ultimately all you got is, don't ever use those guys again because they apparently didn't know what they were doing or didn't do a very good job while they were doing it. So that's really the only explanation I can give at this point is they just didn't do a very good job. There's no legal explanation for it, except that maybe, again, you didn't actually find the right person. That's the only other possibility is that in the company that you used or the individual that you hired to do the search didn't find them because legitimately they were not findable, and maybe this additional data that you found isn't applicable. So it could just be that the data is inaccurate. It could be that the person you hired just didn't do a very good job. And without more information, I really don't know. So hopefully it was that there's some kind of data error and not that the person you hired did a bad job. So here we go. What if a tenant shows up in court and says they moved out, but they did not turn in the key or notify the landlord? Will the eviction case be dismissed for possession? The back rent is owed and move out was abandonment. So I can't speak for every court. There are some sympathetic judges that'll say, oh, you claim you moved out? Case dismissed. I think that's very wrong without some kind of verification. And the landlord should at least be allowed the opportunity to confirm that, because I've had situations where tenants swear on a stack of Bibles they are 100% moved out. And what they mean is they will be moved out by the end of next month. Right? They weren't moved out. They had no intention of leaving. They're in the process of it, but they haven't found a place yet. So once they do find a place, they will be moved out. They were speaking prophetically, not accurately. So should the court take that 100%? No. Do some courts do that? Yes. At the very least, if I were the landlord, I would say, Your Honor, can I at least get an opportunity to confirm this? I want to make sure that not only they are out, but that they've taken all their stuff. I don't want to find out after this case is dismissed that, in fact, they left all their things behind and they left their cousin there who now I have to deal with. And so can I at least have an opportunity, if you plan to dismiss this case, for me to confirm that, in fact, they're out and they took all their stuff? That would be a sensible request, and hopefully your judge would allow that. But if, in fact, they say they moved out, but you're seeking a judgment for unpaid rent, then yeah, they should still get an eviction on their record. It is perfectly valid if they owe you money for you to get your money. But if you're just seeking possession and they claim they're out, but you can't confirm that, I would ask the court for a reset and let the court know, look, if in fact they're moved out, I'll call the court and just dismiss the case because all I wanted was possession. If I got it, then I'm good. But if I show up and it turns out I don't actually have possession, I'm going to need this eviction to force the tenant to actually vacate. So that's how I would handle that situation. Ernie, what are some methods and steps for collections, demand letters? Can you process wage garnishment, anything additional for additional considerations. No, in Texas, there are no wage garnishments for civil judgments. The tax man can do that. That can happen in a family law for arrearages on child support, but that doesn't happen for unpaid rent civil damages, unfortunately. Now, one thing you can do is you can, and I talked about this a little earlier, is you can take a judgment against an individual and abstract that judgment. And what this does is it creates a judgment lien. The best way to do this is by having good information. So let's say you want to get a judgment against some guy named Ernie Garcia. Well, I can assure you there's 1,000 of us just in Houston alone. And so to distinguish me from every other Ernie Garcia, you're going to want my last 3 of my social security number, my last 3 of my driver's license, and my date of birth, which probably should appear in your application. And if they do, it's a lot easier for you to pinpoint which defendant specifically you are naming and who you want this judgment lien to attach to. And by abstracting your judgment with these 3 identifying pieces of information, you can create a judgment lien. Now, this becomes helpful, for example, if in the future Ernie Garcia wants to buy a house, he's going to go through title, probably, and the title company is going to find this judgment lien and tell me, Mr. Garcia, you cannot proceed with the purchase of this home because a lender isn't going to extend this loan without you clearing this judgment lien. It creates a threat to the collateral. So clear this judgment lien, and then you can proceed to closing. Additionally, if, like I mentioned earlier, I own property and now want to sell at closing, I'm going to find out that someone has a judgment lien against me that has to be paid off before I get paid, because it's one of the encumbrances that I need to clear now that my homestead, which previously was protected, but now since I'm selling it, is no longer protected, can be used as a method to collect on somebody else's judgment. So that's one effective way. Other than that, there aren't a whole lot of effective tools for going after a tenant who fails to pay and owes you either rent or damages caused to your property. My philosophy when it comes to tenants and money owed is get them out fast, because by getting them out fast, you're going to reduce your damages. It doesn't help you to have a big fat judgment if you can't collect it. You're better off getting people out sooner rather than later, because that judgment looks good on paper, but if you can't collect it, it's not really worth the paper it's printed on. So, all right, next question. Ooh, this is a long one. Here we go. FPDS. My question is around residential lease contracts and what the rules are for early termination of lease. We've covered that already, but let's see if this is a little different. If a tenant signed a lease in which the lease is active, ongoing, and the tenant would like to terminate signed lease agreement early before the lease is scheduled to expire, tenant has demanded to be released from the lease without penalties with multiple months of lost rent. Tenant has demanded to have a full deposit refund and refuses to pay remaining months of agreed lease term. While landlord has proposed a fair, equitable early termination fee while searching reletting for the new tenant, however, previous tenant has moved out, purchased a 7-figure residence in a fancy area. How much will small claims play a role in this? And what are the rules around this type of situation? What can be expected and recommended as a solution for this? Couple things. So in this case, we're not really talking about an early termination fee. Instead, what we're talking about is the fact that you have been damaged by unpaid rent. And so it's up to you to find a new tenant and mitigate your damages. And maybe you say, Ernie, look, they had 3 months left on their lease. It took me 3.5 months to find a new tenant. I was unable to mitigate. That's fine. You got them for the full 3 months. That's the max in terms of lost rent. There are other damages that you have. Maybe there were damages to the property. And so you weren't able to apply the security deposit adequately to all the damages that were incurred by this breach. So you still have an unpaid portion of fees and charges that are owed to you based on this lease. Will the small claims court help you? Well, That depends on a couple of things. Number one, is your amount within the jurisdiction of the small claims court? If this exceeds $20,000 and you are in Texas, bad news for you, no. You are not within the jurisdiction of the small claims court. Your case cannot be heard in the small claims court because it exceeds that jurisdictional level. But you've got the county court and the district court. And so your claim can be heard. And if it does exceed that amount and your lease allows your recovery of reasonable and necessary attorney fees, you might still be interested in moving forward, especially if there is a seven-figure home now in the mix. And we talked about abstracting a judgment and maybe not recovering in 2026, but maybe recovering somewhere down the line by establishing this judgment lien. Additionally, people who purchase seven-figure homes tend to have money in excess of the minimums that are protected for people with less money. For a married couple, that's $100,000 of assets. If they, for example, have more than $100,000 in assets, or they own more vehicles titled in their name than just two, then all of those additional vehicles are subject to seizure. So people with more means have more to lose and are therefore bigger, better targets when it comes to civil litigation. If they owe you this money and you've got access to it because of the stuff that they own, then by all means, come after them. Now, that could be complicated, and I'm not trying to tell you that civil litigation is easy, but it might be worth looking into, precisely what it takes to get this civil claim off the ground. And as long as you're willing to take it all the way to the very end, you might be able to recover a judgment for the amounts that you are owed. And, whether they'll pay you prior to recovering judgment, that's also possible. A lot of times, people want to avoid judgments, or they don't want to waste time on a case they know that they're going to lose. And so you might find that your former tenant just says, you know what, I give up, I understand, let's just pay what is owed and be done with this. If that's the case, then great. You might get resolution outside of a judgment that you can collect on, or maybe meet somewhere in the middle with some settlement that both you and they are satisfied with. That's another way to resolve things without a judgment. They offer some amount that you are satisfied to accept, and that makes the claim go away. So, consider those as possible options. Certainly, litigation could take a while, sometimes years, to resolve. So I don't know that I would necessarily run into litigation, but it's definitely an option that you should consider if all other options have been exhausted. So, the old demand letter is still something that you can try. Not all demands are taken as seriously as, we might like, but it's still worth it. And perhaps a well-worded demand letter can result in, some better than nothing recovery that you can ultimately get, from your outgoing tenant once they realize, hey, look, I've run this by my attorney, and my attorney says, I'm going to end up owing you this money anyway. Why waste legal fees? Let me go ahead and make this reasonable settlement offer. That's always a possibility. And so, you're going to want to mitigate your damages. You're going to want to find a new tenant as quickly as possible. And whenever possible, if, your attempts to settle don't, bear fruit, then you're probably going to want to consider litigation. That's going to be your next best bet. So that's that. Let's see. 3 months is the max for lost rent that can be claimed. So even if it takes longer to lease, then the court will only allow to collect 3 months. No, that's not technically true. Again, it's going to depend on the market. It's going to depend on your diligence, on your good faith effort to find something. Sometimes, it takes 5 or 6 months. And as long as you can prove to the court, you had the property listed, you had multiple showings, but that in your market, there's maybe a whole lot of rental property and not enough renters. I don't know what the situation is in this case, but, all of those factors matter. So, the court's going to entertain all of these as viable defenses for the defendants. But, ultimately, it might take 4 months, 5 months, 6 months, and all those are recoverable under the lease. Ernie, will you work with clients under judgment payment, split payment for your service? So if you're asking, do we, kind of do a deal where we'll go out and try to collect a judgment and split it, 30-70, 40-60? No, that's not typically what we do here. We tend to work on an hourly basis. And when it comes to collection of judgments, either the tenant has assets and they can be collected, or they don't have assets and it's kind of a waste of time. So we can help you figure out whether they have assets that are worth seizing, and then we can discuss with you what the cost would be to do that. Typically, if we're just setting up an abstract of judgment or a writ of execution, we can typically do that for under $800. And depending on how much you have in a money judgment, that might be, just a fraction of what is ultimately owed to you. And so it makes it worth it if, for example, that the outgoing tenant has their own, vacant lot that they inherited from grandma, and it's just sitting there and subject to seizure. But you got to know that it's out there, and yes, we can file the proper paperwork, contact the county, conduct a constable sale, and then collect on your behalf. But again, you're going to want to know that that's actually out there. So let's move along. We still got a few questions left. I want to make sure I get to all of them. Here's question number 7. Amalfi La Macanita. If an applicant presents a service dog letter with a brother's name and the brother will only visit every other week and he is not in the lease, is the letter valid? Not sure if the dog is the applicant's dog, but the dog will be living on the property. So you only have to extend a reasonable accommodation to your tenant. If the tenant brings on a guest and that guest brings with them a service animal and they have valid documentation to substantiate the need for the service animal, then yes, that person can bring the dog there, and that would not be a violation for your tenant. But as far as the dog living there, once the person with the need leaves, that kind of begs the question, do they need that dog or not? Because if that person leaves their emotional support animal with the tenant, there's no one remaining on the property who requires that use. That changes the status of that animal immediately. So either a tenant occupant requires that animal there, and therefore no pet charges or deposits are required, or the person who does need it takes it with them and only brings it temporarily when visiting the tenants or occupants, and then removes the dog immediately. So that's how I would handle that situation. No, if no one residing on the property requires the use of a service animal or emotional support animal, that animal is not allowed to stay for the benefit of a non-resident, non-occupant. Okay. Ernie, will you work with clients if judgment awarded as payment for your services? Meaning, if the judgment is awarded, then the client will pay for your services. Definitely not. No, because 90% of the time that we win judgments, we have little to no recourse in terms of collection. So we don't do our services based on whether or not we win or are awarded a judgment, because the other case is many times we recover possession without a final judgment. And so we don't want to, connect our good work, which is you want possession and we can get it quickly, But getting it quickly means we don't get paid because we didn't get a final judgment. That's not a good way of working. It would create conflict between the attorney and the client. Instead, we do our work typically on an hourly basis, and our goal is to do everything we can to put that property back in your hands. And if we can collect any amount from the opposing party, we do our best to collect the maximum that is available. But ultimately, the fees are set based on the number of hours that we do our work. That's typically the way we provide our services. Okay. So this next one is a long one. I don't know if you're going to be able to read it, but here we go. Boom. In fact, I'm going to pull myself out of here to make this a little easier to read. Ryan Adams from our newsletter asks, if the HOA lost your HOA check, which you turned in person, are they allowed not to call you and tell you that they applied it to the wrong account? Subsequently, referring your home to a law firm in the Galleria that charges $300 to $350 per hour to simply even speak with you, even though they are representing yourself. We spoke to our HOA, tried to make a settlement agreement, as the HOA via Facebook Messenger suggested we do, because the firm refused to give us any reason for the $10K balance, even though we only owned the home for 3 years and paid 2 years of the HOA fees. The legal assistant refused to let us schedule an appointment to meet with the attorney without paying $500 up front as a legal fee. We were self-represented homeowners, refused to even present our settlement offer to the HOA, charged just $350 to even speak with them in person to make payment arrangements or discuss anything each time. None of these funds were ever put toward our balance, which no one could explain. Then they were threatening foreclosure of the home, which our HOA president knew nothing about. We wound up selling our home because they kept threatening foreclosure and refused to let us ever speak to an actual attorney, just the legal secretary, if we paid the $300 plus per hour to speak with her. We asked multiple times to schedule an in-person or phone meeting with the attorney. Since we were self-represented, she refused. The HOA switched firms after we went under contract to sell our home and had to pay over $10,000 unexplained HOA charges at closing. We didn't want to sell our home and basically got screwed. Now, this sounds less like a question and more like an observation. And so I want to address this really quickly. So, yes, sometimes your HOA is going to do some screwy things. And in this case, definitely that has occurred. Now, I don't do a whole lot of work with HOAs, but I do some. And what I see here is, unfortunately, something that does happen a lot, where the law firm representing the HOA just isn't all that helpful until an attorney steps in. And that's an unfortunate bias that exists out there, but it's a real one, and I've seen it. The moment we step in, the attorneys are very friendly. We get a lot of information very quickly because they know that another attorney is going to put the hammer down and come after them for violation of this code and that code and this code, whereas the individual who has no representation doesn't know how to really speak in a way that motivates the opposing counsel to act. Now, the other truth is, once a law firm becomes involved, those fees are going to rise quickly. That is inevitable because they know that all of the fees they charge are guaranteed by, guess what? The value of your house. And so it doesn't shock me that what probably started off as a pretty meager sum rose dramatically the moment that an HOA was involved. And every time you called and every time you sought some intervention from that law firm, I bet you were billed over and over and over again, not just for your call, but every time they followed up with the HOA and said, hey, this homeowner said the following, bill. Oh, by the way, we got another email from that homeowner. By the way, they called again. By the way, they're interested in doing this. And unfortunately, that running up with a bill is not technically illegal, immoral, or unethical. Courts approve this kind of stuff all of the time. So what I tend to tell homeowners is, it's not really worth it fighting against the HOA. If you've got an issue for unpaid sums, pay them sooner rather than later, because the moment that a law firm gets involved, I mean, they see you as a money pit. They know that they can just keep billing and billing and billing, and there's almost nothing you can do about it. And all of that bill is backed up by the value of your house. They are not afraid to sue you. They are not afraid to collect from you. They know they get a lien, and whether they get a judgment and execute it that way, or they put a lien when you're ready to sell, they'll collect it that way. And so, yeah, I get it. It is aggravating. It doesn't feel fair. I don't know precisely what the facts were in your case and whether there are other injustices or potentially claims that you might have against your HOA or this law firm. But I can tell you these are common practices, and most of the time the courts are just going to let it happen. Sorry. Nobody likes hearing that. I'm not particularly fond of firms that take advantage of people this way. Unfortunately, I see it. And when I can step in and help a homeowner, it's to just do my best to cut. I tell them, look, it's like a faucet that's just running and running and running. I'm not there to put any of the water back in the faucet. It's out. I'm there to turn that spigot off and make sure it doesn't get worse. Yeah. All right. Here we go. Last question. Tom Manchester. I hope you've been hanging in there the whole time, Tom. Finally got to your question. If I have to do extensive repairs, such as foundation work inside a rental, and am I obligated legally to compensate the tenant? There will be big piles of dirt indoors for 1 to 3 days, including in the master bedroom. Okay, so we get this kind of question a lot. If through no fault of the tenant, there is some condition, usually one that's through some casualty event. It just so happens that the foundation is going kaput, and you got to do this. The real question is, to what degree is the home uninhabitable? And if the home is habitable, but it's not completely habitable, is there still a portion of the home where the tenants can reside? If they can reside in 70% of the home and 30% of it is uninhabitable for, let's say, 15 days. But then the work's done, and bada bing, bada boom, you're back in business. Well, that's just a math problem. And so I would say that if the rent, just to make the math easy, if the rent is $1,000 for 1 month and 30% of the unit was uninhabitable for that month, what the property code says under 92.054, Texas Property Code 92.054, if the property is, partially uninhabitable, but still usable, the rest of the spend, then 70% usable, $1,000 worth of rent, 30% of that rent is $300. But it wasn't the whole month, it was half of the month. 15 days were rendered useless. The other 15 days, perfectly usable, right? The work was done, they got back in, 15 days of usable, rentable space. Well, then I would say that that $300 portion gets cut in half. It's $150. That should be returned to the tenant as diminished value. We've talked about that a little earlier. But that's it. You don't need to put them up in a rental, in some other rental. You don't need to find, alternative housing for those 15 days. If they can still use 70% of that unit, they've still got 70% of their benefit, but they shouldn't be paying 100% of the rent. So it's really just a math problem, figuring out what portion of the rental is still perfectly viable and what portion isn't. And so you simply discount the rent accordingly. Yeah, it's going to be inconvenient, but you're doing your part. You are fixing the property. Now, was this a necessary repair? Was it essential to get it done during the tenancy? If so, you could offer the tenants an out. You could say, look, we can just terminate the lease and no penalty on you, you get to go. But if you stay, you're still using 70% of the unit. You're going to pay 70% of the rent. And when it comes to this 30% that you can't use, it's only half a month, so I'm going to charge you half of that 30%, which is 15%, which comes out to $150. That's your discount for the entire month. No, I'm not going to put you up in a hotel for 15 days. You're going to pay $150 less in rent. And that's essentially what the code says is required of you. Now let's change things up. Let's say instead the unit is 85% uninhabitable and only 15% usable. Well, that, for all intents and purposes, it's 100% uninhabitable. There's no way that same family is going to live in 15% of that property. And so because of that, 92.054 also says you can just terminate it and walk away and say, look, because this house is going to be 100% uninhabitable for 15 days, you're just going to have to go. So I'm going to terminate the lease through no fault of your own and really no fault of mine. This is a condition that has occurred. There's a casualty loss here. Something happened, the ground shifted or something occurred that renders the property uninhabitable through, again, no fault on me, no fault on you. So 92.054 says I can just terminate the lease and unfortunately, bring everything to an end, and you, tenant, have to go. That's not usually the most comfortable conversation to have, but it may be a necessary one. Now, could you, if you knew it was 15 days, offer some middle compromise? I say, look, I'll pay for a week, you pay for a week, we'll meet in the middle in that way, but you still owe 100% of the rent, or you still owe, half of the rent, or some other compromise that makes sense to you. Sure, you can do that. But if you're asking me what you're obligated to do, you're just not obligated to put them up in a hotel for those 15 days, or to put them in some other house that maybe you lease momentarily. You can, in that situation, when they have 0% habitability, you can bring the lease to a close and simply say, sorry, you got to move on. If they refuse to move and the house is in a dangerous condition, you might actually have to evict them, right? Because the house is no longer habitable due to this particular condition. So I hope this is helpful. It often helps me to get, a few more, specifics on the facts so that I know precisely what I'm answering. But, when it comes down to these intrusive repairs, you have to do the calculation. How much of the house is still available to the tenant for actual use? If it turns out that the majority of the house is still perfectly usable, well, then you just reduce the cost by the unused portion for the number of days that they cannot use it. That's it. It's a simple math problem. You figure that out, and then you let them know, look, I'll reduce the rent, but hey, you still got most of the house here, and the law only requires that I reduce the rent in this way. If they find that unsatisfying, well, they can go and seek their own legal counsel, and maybe somebody can interpret the law in a way that's more suitable for them, and they can show you what they mean by that. But I don't know anything in the law or anything in the property code or in other judgments that are out there that say that they have to put you up. What may be the case, and this is where having good insurance exists, what may be the case is that the tenant's insurance, their renter's insurance, might actually pay to put them up in this exact situation. That's not a tenant obligation. That might be something their insurance covers. So the first question I would ask, if they refuse to just get up and go, if they really like this house and just, wish they could come back, it might be an issue for their insurance provider. Again, could you meet them in the middle? Could you find some kind of compromise that makes everybody happy? Absolutely, you could. But this insistence that you are obligated to put them up at the Four Seasons, for 2 weeks, that's just not what the law says, and certainly not what your lease likely says. So, I wouldn't be bullied into that arrangement. It's just not the law. Great. I'm glad it does make sense. I'm glad that was helpful. Let's see. What about the AC goes out? It's 102 degrees. They claim they can't sleep, and it will take 4 or 5 days to repair. What then? Again, not being able to sleep, not being comfortable is not the same as being in a situation where they're um, under a realistic threat of their health or safety. Again, if it happened right now, yeah, I'd be uncomfortable in my house if my AC went out for 4 or 5 days right now in March, but my health is not going to be at risk. I mean, the highest it's getting out right now is 83 degrees. Uncomfortable? Yeah. Deadly? No. Even if I get no AC, 83 degrees ain't going to do much harm. And it's not likely going to be 83 degrees in my house at night, right? So, is a situation dire, then you've got an issue where if the whole house is completely uninhabitable, you might have to say, well, then it's time for you to go. If you're in such a dangerous situation, I will make this repair, but if you feel that your life is in danger, then why are you still here? Declare that it is uninhabitable and leave. And the truth is, the moment you complete this repair, if they survived it, right, because it turns out it was perfectly habitable, that claim evaporates the moment the repair is completed. So again, you judge the situation. Is the repair request one that materially affects the health or the safety of an ordinary tenant? If that's the case, you are obligated to do it. But if it renders the house uninhabitable, then 92.054 says you can call it quits. If they don't want to leave, then they agree that the house is still habitable. And once you've completed that repair, their claim for habitability really evaporates at that point. And it's probably just a diminished value issue. That's different. You may say, it took me 4 days. I'm going to reduce your rent by 4 days because of inconvenience. But as far as putting you up in a hotel, that ain't happening. Do you have renter's insurance? Because that's what renter's insurance is for. In these kinds of events, you could utilize your renter's insurance to protect you. But it's not on the landlord. So again, I hope that was helpful. Guys, this has been a long one. We're almost at an hour and 20 minutes. For those of you who stuck around all the way to the end, I hope you found this helpful to you. I love doing this. I'm sorry that I missed last week. I don't mean to miss again, but it could happen. From time to time we get called for emergency hearings and what have you. But I do want to say that I'm glad to be here every chance I get. I appreciate those of you who contributed with questions. I look forward to seeing you next week when our topic will be... I don't have it handy. Anyway, I'm tired. It's time to go. I do want to say thank you again to all of you who showed up and to all of you who consistently show up. Again, I appreciate you very much. Until next time, landlords, happy leasing.